I want to just talk to you, at least initially, a little bit about the law. Ms. Abudu, what's the adequate and independent state grounds doctrine?
Thank you, Senator Kennedy.
You're welcome.
In my practice, I actually haven't had an opportunity to use that principle or doctrine, but my general understanding is that it speaks to the fact that if a federal court is able to resolve an issue based on state law grounds, then that is what should lead in terms of the court's ultimate decision.
Okay. What is the selective incorporation doctrine?
That also, in the voting rights or civil rights context, is a term that I haven't had to come across. But what I do know is that as a legal research and writer, and for sure confronting possibly new areas of law, I look very forward to doing my due diligence in terms of making sure I'm familiar with doctrines such as that one.
Do you know what it is?
So no, I'm not familiar with it sitting here today.
Selective incorporation doctrine? Okay. Well, you're going to see a lot of it if you're confirmed on the 11th Circuit. Can Congress pass any law that the Constitution doesn't prohibit?
Based on the frame of your question, I would say yes, that sounds right.
So you think Congress has plenary power?
Well, I would first look to what the Supreme Court has said in terms of following precedent.
No, but I'm interested, if I could, Counselor, in your opinion. Does the United States Congress have delegated powers or plenary power?
Well, the Congress has both, I would say, from my general understanding. Again, it depends on the context and the issue, but
Okay.
it is.
Can you explain the difference to me between strict scrutiny and intermediate scrutiny?
Senator, strict scrutiny is the highest level of scrutiny that's often applied in constitutional cases.
What's the definition? I'm sorry, go ahead. Excuse me.
So it requires that a state, when enacting a law or regulation, have a compelling governmental interest for doing so, and that the law is narrowly tailored to achieve that interest.
Okay.
And then intermediate, did you say?
Yeah.
Okay, so intermediate speaks to the issue of having a substantial interest or that is, or an important governmental interest that is substantially related.
Okay. Do you believe that the meaning of the Constitution is immutable, or does it change over time?
Senator, I would say that the Supreme Court in some cases has analyzed that issue, and the response really does depend on the context and the issue. But what the court does or has done in its approach, of course, is look to the plain meaning of a statute or of the Constitution, because that really is where the inquiry should start. And if the language is plain, then that is where the inquiry can end.
Okay, thank you for that. You were involved in a 2021 report from the Southern Poverty Law Center about voting in Louisiana. Did you say, quote, racist white Southerners, close quote, and, quote, hostile white voters and governmental officials in Louisiana continue to make local polling places and early voting locations threatening spaces for black voters? Did you say that?
Senator, I do not believe that I said that. I haven't read that publication in some time.
Will you help write it?
I helped to draft the publication and approved it, but I'm not familiar with that language.
You don't? Okay. In that same report, did you say, well, tell me where in Louisiana local polling places and early voting locations are threatening African-American voters? You said it, so which polling places?
So again, Senator, obviously I don't have that report in front of me to be able to read and remind myself of the examples that might have been shared. But what I can say is that Louisiana.
Let me cut you off because I'm going to run out of time, Counselor. Let me ask you one more. In August 2021, we're not talking 20 years ago, we're talking 2021, you were involved in another report by the SPLC. And you said that voter identification, photo ID to vote, is burdensome and does not serve any legitimate state interest. Do you really believe that?
Senator, identification for voting is something.
Yes, but first, do you really believe that? You said it. You meant it?
A routine judicial confirmation hearing quickly turned into a tense back and forth as Senator John Kennedy put judicial nominee Nancy Abudu under intense scrutiny, from constitutional law to election integrity and her past work with the Southern Poverty Law Center. Kennedy fired off a series of pointed questions, challenging both her legal knowledge and positions reflected in reports she helped produce. While the nominee frequently pointed to Supreme Court precedent, Kennedy repeatedly pushed for direct answers. Here's how the exchange unfolded. Senator Kennedy opened by examining Abudu's understanding of constitutional law. He asked her to explain the adequate and independent state grounds doctrine. Abudu acknowledged that it wasn't a doctrine she had dealt with in her legal practice but offered a general explanation of what she understood it to mean. Kennedy quickly followed up with questions about the selective incorporation doctrine. This time, Abudu said she was not familiar with it. The senator noted that judges on the 11th Circuit regularly encounter those constitutional issues and continued pressing her on Congress's powers, delegated authority, plenary authority, and the different constitutional standards courts use when reviewing laws. Although Abudu explained concepts like strict scrutiny and intermediate scrutiny, Kennedy repeatedly challenged whether her answers demonstrated the depth of constitutional knowledge expected from a federal appellate judge. The hearing then shifted from legal doctrine to judicial philosophy. Kennedy asked whether the Constitution has a fixed meaning or whether its meaning evolves over time. Rather than embracing one constitutional theory over another, Abudu responded that judges begin with the Constitution's text and are bound to follow Supreme Court precedent when interpreting the law. Like many judicial nominees before her, she avoided expressing broad personal views about constitutional interpretation, emphasizing, instead, that a judge's responsibility is to faithfully apply existing law. But Kennedy wasn't finished. If you're enjoying this coverage of today's hearing, be sure to like this video, subscribe to the channel, and turn on notifications so you never miss the biggest moments from Capitol Hill.
The Supreme Court in Crawford v. Marion County has already upheld voter ID laws as per se
Yeah, but you said it didn't serve any legitimate state interest. Do you believe that?
Again, Senator, without that language in front of me, it's hard to understand the context.
You said it. Here it is, August 2021.
Well, there are cases.
I'm just asking you to explain to me why having to prove you are who you say you are before you vote doesn't serve, you said it doesn't serve any legitimate state interest. I'm just asking to explain that statement to me.
I understand, Senator Kennedy, and again, without being able to see the language that appears before and after, it's hard for the context.
You deny that you said it?
I can't say that I haven't seen that language in front of me, but what I do know is that there have been voter ID cases in which courts have found that
I'm familiar with the case law, but I'm asking what you think, because you may be on the 11th Circuit. Do you believe that voter ID is inappropriate?
My commitment is to uphold the Supreme Court's decision in Crawford v. Marion County.
I know, but here you said it was inappropriate. You deny that?
Well, again, Senator, it would be helpful to know if that section of the report also cites to cases in which federal courts have found that certain voter ID laws do pose an burden on voters.
Thank you, Senator Kennedy. Senator Booker?
I'm going to yield to Senator Whitehouse, who's more seniority.
Senator Whitehouse.
The questioning then moved to Abudu's previous work with the Southern Poverty Law Center. Kennedy referenced a voting rights report that included statements about racial discrimination in Southern elections and concerns about voting conditions in Louisiana. He asked whether she agreed with those statements and whether she had personally approved the report. Abudu acknowledged participating in the drafting process but said she could not specifically recall the language Kennedy was quoting without seeing the report. Kennedy then asked her to identify the polling locations referenced in the report. Abudu replied that she didn't have the document before her and therefore couldn't discuss the specific examples being cited. With time running short, Kennedy moved to another issue involving voter identification laws. The sharpest exchange of the hearing centered on voter ID requirements. Kennedy cited language from another report that questioned whether photo identification laws meaningfully advance legitimate state interests while placing burdens on certain voters. He repeatedly asked Abudu whether she personally agreed with that position. Rather than offering a personal opinion, Abudu said she would not comment on isolated excerpts without reviewing the full context of the report. She emphasized that if confirmed to the federal bench, her responsibility would be to follow Supreme Court precedent, including decisions that have upheld voter identification laws. Kennedy continued pressing for a direct answer, but Abudu consistently returned to the same point: a judge's personal views must take a back seat to the law and binding precedent. Moments later, the committee's questioning time expired, bringing the exchange to a close. The hearing highlighted two very different approaches to a judicial confirmation. Senator Kennedy focused on testing the nominee's constitutional knowledge and examining her previous advocacy, while Nancy Abudu consistently framed her answers around judicial restraint and adherence to Supreme Court precedent. The exchange is already drawing attention as lawmakers continue evaluating her nomination and what her record could mean if she joins the federal appellate court. What did you think of the hearing? Did Senator Kennedy raise important concerns, or did the nominee appropriately avoid commenting on issues that could come before the court? Let us know your thoughts in the comments below. And if you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.